Oyez, 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 the Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone, and welcome. We are pleased to have you with us today. We have 3 cases on the morning docket, which we will call in the order in which they appear. Let me remind the appellants that you have the right to reserve up to 5 of the 15 minutes you have for oral argument. In order to program the clock, when you come to the podium after you introduce yourself, please announce how many minutes you wish to reserve, and the clock will be programmed accordingly. As you know, the Court of Appeals of Tennessee is one court, and all of the judges, we travel the state and sit with judges from each of the 3 grand divisions, and today we're honored and personally pleased to have Judge Kenny Armstrong from Memphis, Tennessee with us today. And he tells us that he has prepared some bone-crushing questions for all the counsel, and so you should just brace yourself when you come to the podium. So there may or may not be some truth to that. I'm not sure, but anyway. Okay. All right, please call the first case.
Mankin Media Systems, Inc. versus Timothy Corder.
Counsel, if you wish, you're welcome to go to counsel table. And good morning.
Good morning. May it please the court. Cole Dowsley of the Nashville Bar on behalf of Mankin Media Systems Incorporated. I would like to reserve 3 minutes for rebuttal, please.
3 minutes, yes, sir.
This case comes to the court following the trial court's confirmation of a final arbitration award. The appellant raises 4 issues on appeal as to errors in the trial court's rulings, all of which are somewhat intertwined and related, but each of which we submit should result in reversal of the trial court's final order confirming the final arbitration award. This appeal concerns the enforceability of an arbitration clause under the Tennessee Uniform Arbitration Act. More specifically, this appeal concerns whether a provision may be enforced when the provision is part of a document that does not constitute a contract. For purposes of this appeal, the facts of the underlying dispute are largely immaterial to the issues before the court. So unless the court would like a recitation of the facts, I do not intend to spend a lot of time on the factual background of this dispute.
We've read the briefs and we look forward to the finite nuances of your argument.
I do think the procedural history is important to understand how we got to this point and what transpired in the trial court. This was an action that Mankin Media brought against a former employee, and it involved claims of trade secret infringement, breach of contract, related business torts. The complaint was filed in the Williamson County Chancery Court. In response to that, the defendant filed a motion to dismiss, which was in essence a motion to compel arbitration. Mankin Media opposed that motion on the basis that the arbitration provision was unenforceable. The trial court granted the motion and compelled the parties to arbitration under the mandates of the Tennessee Uniform Arbitration Act, and so the case proceeded to arbitration in front of Matthew Sweeney.
This arbitration clause was in an employee handbook, right?
That's correct.
The employee handbook was prepared by Mankin Media.
That's correct.
But they didn't want to have arbitration.
Their position, beginning with Mankin Media's response to the motion to dismiss, was that the arbitration provision was unenforceable, and
so their position was that their own arbitration provision that they put in the employee handbook was unenforceable.
That was their position.
Okay, I just wanted to make sure I understood.
Let me ask you, counsel, how do you end up with a breach of contract claim in your complaint if your argument is that the handbook is not a contractual agreement between the parties?
I think the real issue is that the trial court never made that determination in determining whether or not to compel arbitration.
No, but I mean, at the outset, you file a complaint and you allege a breach of the contract, and the contract that you allege was breached was the handbook. I'm just trying to understand how the handbook becomes a contract in connection with your complaint, but then when the other party says, okay, contract, it has a provision for arbitration, I want to arbitrate the claim. How do you explain that?
Well, I think the explanation is that immediately upon the trial court compelling arbitration, the defendant took the position, this is not a contract. He filed an answer denying the existence of a contract throughout his briefing in the arbitration proceeding and his sworn testimony in the arbitration proceeding, all of which is in the record before this court. He denied the existence of a contract. The arbitrator specifically found that the handbook did not constitute a contract. And what we have is a trial court that never undertook its obligation to determine whether or not the agreement was in fact a contract. And that's what the mandates of the Tennessee Uniform Arbitration Act require. It requires the existence of a contract in order to compel parties to arbitrate. The entire crux of our appeal is that arbitration is a creature of contract. And under the mandates of the Tennessee Uniform Arbitration Act, litigants cannot be forced to arbitrate claims they did not contractually agree to arbitrate. And the breach of contract claim set forth in the original complaint, that was not the only claims brought by Mankin Media. There were business tort claims, there were Tennessee Trade Secret Act claims, all of which were outside of the breach of contract claim. And the trial court at the outset, under the mandates of the Tennessee Uniform Arbitration Act, should have undertook its obligation to determine whether or not there was an enforceable agreement to arbitrate between the parties. And if we go back and look at the trial court's order, what we have is a one-sentence ruling that says the arbitration agreement is enforceable. And there's no factual analysis, there's no legal analysis, there's nothing for this court to look at and determine what did the trial court do to determine whether or not the arbitration agreement is enforceable.
Well, isn't that a question of law, whether the arbitration agreement is a contract?
It is a question of law.
Right. While the handbook itself says, or much earlier, that this is not a contract, it's a guideline or what have you. But the arbitration clause itself has very unique and specific language that appears to me to say that the parties have agreed to bind themselves to arbitration. So explain to me why that one sentence doesn't mean what it, I believe, literally says.
And the question of law as to whether or not it's a contract requires the court to look at the entire document. And that's a bedrock principle of contract law. We have to look at the four corners of the document. We cannot, the trial court cannot base its determination on one clause alone. It cannot base its determination on one sentence and one clause alone. It must look at the entire agreement. And that's what the arbitrator did. The arbitrator looked at the entire agreement and said, this handbook does not constitute a contract. Now, both the trial court and the arbitrator tried to sever the arbitration provision from a document that otherwise does not constitute a contract. And we believe that was error. The trial court's August 2021 order confirming the arbitration award and denying our motion to vacate, the trial court relied on this severability doctrine and cited the Tennessee Supreme Court case, Penske, a 1990 case, for the prospect of severability. That was not an arbitration case, and in that case, we were not talking about a document that itself does not constitute a contract. I'm not aware of any Tennessee appellate decisions that specifically address the severability doctrine in the context of the Tennessee Uniform Arbitration Act. And I think this court has an opportunity to clarify that issue as a matter of law under the Tennessee Uniform Arbitration Act. There are decisions, Tennessee appellate decisions, that address this issue under the Federal Arbitration Act. One of those is Clayton versus Davidson Contractors, and in that case, the court essentially said that applied the severability doctrine to an arbitration provision, but in that case, the court says we must distinguish that here because we're not talking about an underlying contract that should be voided because it's unconscionable. We're talking about an issue that goes to whether or not the parties formed an agreement. And that's the exact issue we have here. We are challenging whether or not the parties formed an agreement in terms of the employee handbook. And the Clayton decision says the contract formation issue precludes application of the severability rule. And I think that's exactly what we're dealing with here. And the Clayton court also talked about this hopelessly circular result that may occur if the trial court does not undertake its obligation to determine whether or not a arbitration agreement is enforceable and whether or not the parties actually formed a contract, because arbitration is a creature of contract. So not only are we in a situation where the court failed to make a finding as to the contract formation issue, which resulted in this case being compelled to arbitration, but also the trial court erred in refusing to vacate the arbitration award. And that's another issue we have raised on appeal. And the TUAA, and I'm speaking specifically to section 313, says that upon the application of a party, a trial court shall vacate an award where the arbitrators exceed their powers. And we submit that
Thus the question is, did the arbitrator exceed his or her power?
And this goes to the principle that the arbitrator's power is derived by contract. Mm-hmm. And so we're back to the crux of this argument as to whether the parties formed a contract. And I think it's important to note that Mr. Corder, the appellee, has specifically conceded that the handbook does not constitute a contract. That's conceded in his briefing, and it's also conceded in sworn testimony and in the answer filed in the arbitration hearing, all of which is before this court. And we submit that the arbitrator exceeded his powers because he specifically found that the handbook did not constitute a contract. And that's the document that gave the arbitrator his power to even decide the dispute. So he essentially divested himself of authority to decide the dispute by holding that the document that gave him the authority doesn't exist in the first place. And we've cited decisions where courts have vacated arbitration awards where arbitrators exceed their powers, and this is one of those situations. So we respectfully request that this court reverse the trial court's order compelling arbitration and confirming the arbitration award and remand this case back to the trial court.
Thank you, Mr. Dowsley. We'll hear from you further on rebuttal. We'll now hear from the appellee. Good morning and welcome.
Good morning, Your Honors. My name is Abigail Mabry. May it please the court. I represent.
Do me a favor.
Yes,
say your last name again.
Mabry.
Mabry, thank you.
Yes, Your Honor.
My apologies.
I'm also from Memphis, Judge Armstrong, so really excited about that Grizzlies win last night. I'm sure you are as well.
Well,
Your Honor.
Judge Bennett and I will try not to hold that against you.
Yes, sir. Your Honor, today this court has the opportunity to essentially protect the finality and integrity of arbitration. And for this court to make an informed decision in this case, it is important, like Mr. Dowsley said, to understand how we got here. So I'm sure you know from reading the briefs and looking through the trial record that in April of 2019, Mankin Media did file a complaint against Mr. Corder in the Williamson County Chancery Court, alleging, among other things, but breach of contract. And the specific contract he alleged Mr. Corder breached was that employee handbook. Mr. Corder did file that motion to dismiss, did not concede or make any argument related to the enforceability as a handbook as a whole, didn't take a legal position at that stage, wasn't required to take a legal position at that stage, but did state in the motion to dismiss that the contract Mankin Media was alleging Mr. Corder breached contained an arbitration provision that seemed to be enforceable, asking the trial court to make a determination on that. And the trial court did find that that arbitration provision was enforceable between the parties. So we went to arbitration, Your Honors. Yes, Your Honor.
The arbitration clause, to me, does appear to be a contract. Yet, as Mr. Dowsley mentions, we need to read the entire contract together in context. And an earlier provision of that handbook says this is not a contract. So how do you distinguish those two conflicting declarations?
Yes, Your Honor. So it was Mr. Corder's position, and it's still Mr. Corder's position and our position, that the handbook in and of itself doesn't constitute a contract, but there are provisions in that handbook, one of which is the arbitration provision that contained mutually binding language on both parties. And the arbitrator found, and the trial court also found at the motion to vacate and motion to confirm stage, that that arbitration provision was properly severable from the employee handbook and could be incorporated into the overall at-will employment agreement between the parties.
Normally, severability comes into play where you have a contract and then a certain parts of it is not enforceable. Could be because the provision itself was unconscionable. But then you sever out another part of it. If you don't have a contract, how do we ever sever out a provision?
Yes, Your Honor, I think it's an important distinction to say that it wasn't that there was no contract between the parties, just that the employee handbook in and of itself did not constitute a contract, but there was an overall at-will employment agreement between the two parties that was a contract, and there were writings that were incorporated into that, one of which was this arbitration provision, which was one of the only provisions of the handbook that was mutually binding on both parties, so that it's distinguishable from other provisions of the handbook that Mankin Media alleged Mr. Corder breached, which it could alter unilaterally, which didn't mutually bind the parties. So the arbitrator made a determination that that arbitration provision was severable and could be incorporated into the at-will employment agreement. And the trial court agreed and found the same thing. So we do argue that that provision is properly severable, and properly incorporated into the overall at-will employment agreement. It's important to point out, however, that the issue of the enforceability of the handbook as a whole was never an issue that was raised to the trial court at the motion to dismiss stage. Mankin Media did not argue at the motion to dismiss stage that the handbook was not a contract. They didn't even argue technically that the arbitration provision was unenforceable. Mankin Media actually argued that the arbitration provision wasn't enforceable in and of itself, in that it called for a secondary arbitration agreement to be signed between the parties in order for arbitration to be appropriate. And the trial court read briefs on the matter, he heard an argument on the matter, and then he made his determination. But that issue of the enforceability of the handbook as a whole was never raised before the trial court. And that's an important distinction between many of the cases that Mankin Media cites in their brief and in their reply brief, because in those cases in which the trial court properly made a determination on the enforceability of the contract in the first place that contained an arbitration provision, that issue was brought before those courts. And in this case, it was not at issue before the trial court. There was no reason for him to have to decide that, because it wasn't at issue at that time. And Mankin Media had procedural mechanisms available to it throughout the entire course of this proceeding, Your Honors. After the defendant filed his answer claiming that the handbook did not constitute a contract, to get the case back to the trial court to have this issue adjudicated. They could have filed a motion to stay arbitration at any time during the proceedings in order to take the case back to the Chancery Court and have the enforceability of the handbook as a whole litigated. But they didn't do that, Your Honors. We had 606 days from the date that the trial court's order came down in the motion to dismiss on August, I think, 19th, 2019, until the date of the arbitrator's award, April 16th, 2021, that they had procedural mechanisms available to it to get this issue back in front of the trial court, and they didn't do that, Your Honors.
So, let me make sure I understand you. You're saying that once the request and/or decision was made, let's go to arbitration, at no time after that point did Mankin object to the arbitration until the arbiter rendered its decision?
That's correct, Your Honor.
Okay.
That's correct. The first time that an objection came was in Mankin Media's motion to vacate the arbitration award. And there were procedural mechanisms in place. There's no appeal as of right on a motion to compel arbitration, but they could have appealed. They could have attempted an interlocutory appeal. They didn't do that. They could have filed a motion to stay during the arbitration proceeding. They didn't do that. They also could have objected to the arbitration during the proceeding in order to preserve their right to justify vacatur under one of the statutory prongs that calls for this very specific incident, Your Honors. So Tennessee Code 29.5.
Let me ask you, counsel.
Yes, Your Honor.
Couldn't they also wait and file a Rule 3 appeal challenging the trial court's decision to send the matter to arbitration?
Yes, Your Honor.
And that's what they did here, isn't it?
Yes, Your Honor.
Okay.
Yes, that's true, Your Honor. They did avail themselves of a procedural opportunity at some point, obviously, by filing this appeal, but they had other options available to it during the course of this proceeding and didn't take advantage of those. And public policy and case law from this court, from the Tennessee Supreme Court, encouraged the finality of arbitration and preserving the integrity of arbitration. And we had 606 days of litigation in this case, over 9,000 pages of discovery, hours of work, depositions. We had a 4-day arbitration trial, and arbitration was never objected to by Mankin Media during the course of this proceeding. So the statute for vacatur, Your Honors, also allows, it states the trial court must vacate an arbitration award in one of only 5 specific circumstances. One of those is the exceeding powers provision, which is what Mankin Media argued in their motion to vacate. However, their real argument, Your Honors, is under a different statutory provision which says that when one of the parties alleges that no arbitration existed, or no arbitration agreement existed, and the issue was not adversely determined during the proceedings, and a party raised an objection to arbitration during the arbitration, then the trial court must vacate the arbitration award. Mankin Media's argument is that no valid arbitration agreement existed between the parties. So that falls under a different statutory prong than what they argued in their motion to vacate, Your Honors. But they could not qualify under the statutory prong their argument really falls under because they did not object to the arbitration proceedings during the arbitration. So essentially, trying to shoehorn an argument into a different statutory provision just to preserve the argument, Your Honors. The arbitrator cannot divest himself of authority that he didn't grant himself in the first place. It was the arbitration provision, the trial court's order, which granted the arbitrator authority to adjudicate the dispute. The arbitrator can't divest himself of authority when he's not the person who granted it in the first place, Your Honors. Additionally, Your Honors, again, public policy encourages the finality of arbitration awards. The Tennessee Supreme Court in Arnold versus Morgan Keegan stated that the finality and enforceability of an arbitration award must not be undermined or compromised, but must be preserved and enhanced. That court also stated that to permit a dissatisfied party to set aside an arbitration award and to invoke the court's judgment upon the cause would render the arbitration merely a step in the settlement of the dispute instead of its final determination. Mankin Media had procedural options available to it throughout the almost 2.5 years that this case was in arbitration, Your Honor, or during the entire course of this proceedings. It didn't take advantage of the procedural mechanisms that it had available to it. Your Honors, give me one moment.
Certainly, take your time.
Another important statutory issue to point out, Your Honors, is that the Tennessee Uniform Arbitration Act also states that an order to compel arbitration is not appealable. And that's one of the reasons why Mankin Media's appeal of the trial court's August 2019 order should not be considered by this court, because the statute says that an order to compel arbitration is not appealable under the statute.
But you can appeal it after the fact.
I'm sorry, Your Honor.
You're saying an order to compel arbitration is not appealable, as though it's never appealable, but it is appealable under a Rule 3, isn't it?
Yes, Your Honor. Yes, Your Honor, that's correct. Just to summarize, Your Honors, in this case, the issue of whether or not the employee handbook constituted a contract was never at issue in front of the trial court. The defendant didn't raise the issue, the plaintiff didn't raise the issue. There was no reason for the court to decide something that wasn't at issue at the motion to dismiss stage. And Mankin Media had procedural mechanisms available to it that would have preserved the efficiency of the proceedings and protected the integrity of arbitration by filing a motion to stay as soon as it realized that the defendant's legal position was that the handbook did not constitute a contract, and Mankin Media did not do so. Yes, they have appealed at this stage, Your Honor, but this is after almost 3 years of litigation. And we believe that the case law in this case and Tennessee policy strongly encourage protecting arbitration, Your Honors. And also, I want to point out that it's encouraged by case law that if you find that the arbitrator did exceed his powers, that the appropriate remedy encouraged by the courts is not to vacate the entire arbitration award, but rather to strike the portions of the award that are found to have exceeded the arbitrator's powers and try to protect the award and keep the award intact as much as possible.
But here, isn't it an all or nothing decision?
Your Honor,
I don't see where we could fashion a reasoned decision that says we're going to set aside half of what the arbiter did.
Yes, Your Honor. Okay. I think there is a way, because in the arbitrator's award, he did make a determination that the handbook did not constitute a contract. However, he went on to do a damages analysis as if the handbook did constitute a contract, and found that Mankin Media had not proved any damages from any alleged breach committed by Mr. Corder based on any provisions of the handbook. So we believe it is possible to strike the portion of the arbitration award that found that the handbook did not constitute a contract, preserve the damages analysis.
Okay. Now I understand what you're saying.
Yes, Your Honor.
Okay. I misunderstood.
Yes, Your Honor.
Thank you.
So Tennessee courts encourage striking those provisions of an arbitration award that have exceeded the arbitrator's powers and protecting the award as much as possible in order to preserve judicial resources, protect the integrity of arbitration. And we believe that is possible for this court to do, even if you find that the arbitrator did exceed his powers in making the finding that the handbook did not constitute a contract.
All right, thank you, Ms.
Thank you, Your
Mabry.
Honors.
Mr. Dowsley, you have rebuttal.
In response, I would like to address a couple of issues. First, Judge Armstrong asked counsel, how can an arbitration provision be severed from a document that doesn't constitute a contract? And the answer to that question is clearly, it cannot. This jurisdiction has not adopted the argument set forth by the appellee that an arbitration provision can be incorporated into an at-will an oral at-will employment agreement and enforced. There is absolutely no authority standing for that proposition. The authorities are clear under the mandates of Granite Rock and Tennessee appellate decisions that have relied upon and incorporated Granite Rock, that trial courts must satisfy themselves that parties agreed to arbitrate a particular dispute prior to compelling arbitration. And our position is that the trial court failed to do that, failed to make that determination. And that's a question of law that this court can answer and can review de novo. And the answer to that question should be that no contract exists. There's been a lot of discussion today about appellant taking certain positions in front of the trial court. And the difference is that the arbitrator later specifically found that no contract existed between the parties. And at that point, of course, Mankin Media's response was to question how it was possible that the arbitrator even had the authority to issue a final award if he found the parties didn't enter into a contract. And so that's specifically why Mankin Media raised this issue in response to the arbitration award.
Can you tell me why the paragraph about dispute arbitration isn't itself a contract? It has all the mutual promise language and everything. So why isn't that paragraph a contract?
That paragraph is not a contract because Tennessee contract law, and I'm citing the Frizzell construction case, the Tennessee Supreme Court case, says no single clause in a contract can be viewed in isolation. Rather, the contract is to be viewed from beginning to end, and all of its terms must pass in review, for one clause may modify, limit, or illuminate the contract. And I think if we look at the contract as a whole, which the arbitrator did, which the trial court failed to do, we see that it clearly does not constitute a contract. And that's a fact that's conceded by Mr. Corder in his briefing, in his appellate briefing, and also in the record before this court. And the public policy arguments submitted by Mr. Corder do not overcome that bedrock principle of contract law that there must be an enforceable contract between the parties for a trial court to have the authority to compel the litigants to arbitrate. And that's where the trial court erred.
Thank you, Mr. Dowsley and Ms. Mabry, for your arguments. We'll take this matter under advisement.